Has the meeting started?
Not just yet.
Okay.
We had one meeting, we're finished with that one and we started, about to start the second.
Okay.
It's a process.
All right. We'll go ahead and call to order the regular council meeting with the continuation of determination of vested rights hearing for December 9th, 2021. Begin with a moment of silence. Amen. All right, need a motion to approve our agenda. Craig makes the motion, second. Joey, all in favor? Unanimous. All right, need to motion to approve the consent agenda for the minutes of last meeting and then the water and other miscellaneous. Joey makes that motion, second. Tom, second. All in favor? Unanimous. All right, do we have an attorney report? All right, we're gonna go ahead and. All right, we're gonna go ahead and reopen and continue the vested rights hearing. And I'm gonna let Warren summarize where we were when we left off and remind us of the remaining procedures that we have.
Sure. So procedures will be the same as they were last time. There'll be presentation of documents or witnesses. They can talk. And after they get done, we'll have the opportunity to ask questions. We'll continue that until we're through. Where we left off last time was there were documents, I think roughly from exhibit 9 or 10 through 19, various things that have been presented that council had wanted to consider. We continued it to today. We'll see what else was brought up or put forth, but the idea would be if there's anything else that the applicant wants to include or discuss, we'll go from there. Same thing with any questions that council may have on documents that were presented last time. Had some time to look at them or anything that's presented new. We'll go forward from there.
And then we conclude with the closing statements from the presentation by the presenter. Okay. All right.
All right. Mayor Early and members of the council, Matt Reeves, have Marsha Brock, Brian Irvin, Clint Irvin back. David Irvin's under the weather, and the best way to keep him home was for Johnny Irvin not to come also. So pardon their absence, but they definitely appreciate your attention the last two nights as well as tonight. In a moment, I'm going to call Marsha Brock to introduce that timeline that I believe got emailed to you and that you have a copy of tonight, which we marked Exhibit 19A. We also provided a copy of the transcript of the November meeting, which is Exhibit 20. One thing I wanted to confirm, and this may get somebody off the Zoom. One of the 23 lots was purchased since the application was filed by a neighbor, and that was lot number 4. Mr. Tillery actually brought that out in his questioning in November. So we wanted to confirm that lot number 4 is removed from the application. And the purchaser of lot number 4 has confirmed he is not interested in short-term vacation rentals. So that one resolved itself. There are 22 lots left. There were some typos in various listings of the lot since the application was filed, but there is a lot 22, and then lots 23 and 24 were combined. So that's how we get to 22. You have 2 lots that were combined, and then there was one additional lot 22, that was not in one of the listings. So we have a total of 22 lots, 9 of which are on the lake or near the lake, and the rest of them are up on Hickory Nut Mountain. So just want to clarify that again.
Just a question on that. Here,
Sure.
so I'm looking at the transcript. And
Yep.
not the application. It's lot 22A, 23 and 24. So it was 23 and 24 were combined.
23 and 24 are combined, and I think they're listed as lot 23, but it's really 2 lots. And then in addition to lot 22A, there's lot 22. So you take one away and then you add one back, that's 22. There's a lot,
I was thinking there was 24. Yeah.
right.
You removed
2 of
one.
them, right, 2 of them got combined, and then one of them was just left off the list in the transcription. But to make it simple, lot number 4 is out. We're not seeking anything on lot number 4. It's owned by somebody else now. A neighbor bought it. All right, at this point, we'd like to recall Marcia Brock. And Ms. Brock, you were sworn in last time. I understand you're still under oath, right?
Yes.
All right. Did you compile this timeline that we passed out as Exhibit 19 since the last meeting?
Yes.
Was that done in response to some of the questions about what did you do on the Hickory Nut Mountain lots before the ordinance was enacted in July of 2022 or
Yeah.
2020?
Yes, it was.
And did it present some of the other documents that were mentioned in your testimony?
Yes.
Okay. In addition to compiling this timeline, did you and the Urbans research the number of short-term vacation rentals that are marketed in Raven County and Habersham County?
Yes, we did.
And what did you find from that?
We found that in Raven County alone, that there is more than 250 short-term vacation rentals. And in Habersham County, there is more than 200 short-term vacation rentals. And of which 90% of all of those are in residential districts.
I believe that's all we have in the way of presentation. We're glad to answer any questions and reserve time for closing statement.
Anybody got any questions? So there was a document that you had given out at the last hearing that looked pretty similar to the one that was emailed out this week. Is that fair to say?
There have been a couple different timelines.
And I think it's exhibit 17. My copy, but exhibit 17 to me looks pretty much to be the same timeline as what's called the 19. Is it 19 or 19? Okay. Pretty similar.
It's pretty similar. There have been a couple of additions.
Maybe a couple of deletions too. I'm gonna go off of the one that we marked, that is 19A. That's the most recent one. If you look there, there's a entry, it's the second one from the bottom, May 27th, 2020. That's the date that Ronnie Davidson began to do the drawings for the cabins.
That's correct.
Okay. And he hadn't done any cabin drawings before that.
Prior to that date, he had not done any cabin drawings. That's correct.
And then third page of this. It's the July 18th, 2020. where it talks about petition. That petition is, and I think I know the answer to this, but just to make sure. That petition was the one that circulated at the hearings without the work, right? One was signed by residents, not the petition for vested rights.
That's correct.
And then how was J and D notified of the existence of the petition? That's the last line. That's in the box.
We were notified of, we were not notified of the existence of that petition until the day that ordinance was voted on and passed. And we were notified of it at that meeting.
So this is after the public hearing. That's what we-
Yes.
So then in what was exhibit 17, there was an entry for August 17th. One for August 19th. August 17th. That's not in the 17th, 19th, not in the one for 19th. But I just want to make sure, because otherwise these timelines generally match up.
Right,
So that was one.
that is correct.
All right, and then there's an entry, and I'm looking back at 19A, which was the new one. There's an entry there. It's 10/1/2020. It's on page 3. Talks about, that's the date of the first vested rights hearing, which was continued because of the time frames. And it says here, the hearing is yet to be completed. But during that time period between 10/1, when the timeline was prepared, there had been discussion about rescheduling, right?
Not to my knowledge. I mean, we knew at some point in time that it was going to be completed, but we had not discussed any definite dates for that to be completed.
And then on 12/10/2020, same page, but block and the couple blocks there. It talks about the Tallulah Falls Art Center being sold to hotel developer. Now, the Tallulah Falls Art Center is zoned highway business district.
Yes, I believe that's correct.
But I mean, I'll phrase it another way. It's not in a residential zoning district here.
That's correct. It's all on the main highway.
And then the timeline ends, the same timeline ends with June 11th, 2021. With, it says stop work notice related to steps to access. That's where it kind of ends off. But subsequent to that, the plans, the revised plans were submitted and the permit was approved for the steps. Right?
Yes, they were approved. With revisions.
And I'm just gonna hand you an email that there that I'll mark. It's not one that I anticipate you may have seen, but it is an email from Reeves to me dated October 25th, 2020, approximately 25 days after the first vested rights hearing. It talks about rescheduling the vested rights hearing to a date, which I believe was October 26th. So I know it's been over at this point, so I don't anticipate you to remember all of that, but in light of that email, that helped refresh your recollection all about scheduling for continuation of this beforehand.
I mean, I was aware that it was going to be concluded at some point, but as far as a definite date or anything being set, I was not aware of any definite date being discussed.
So there's not anything that should be read into that block on 10-1 about the hearing being continued as yet to be concluded. It's just more of a factual statement. We need to kind of organization that is worked out about not continuing.
Correct.
And I think last time there was a fair amount of discussion related to the land disturbance permits, and I can rehash most of it because I think David answered most of the questions that I had on them. But there were a few of them, I think, that he said you had been kind of the point person in applying for and receiving those permits from the town. So would that be a fair statement?
Yes, that's correct.
So on the land disturbance permits, that was mainly for grading, clearing, establishing ground cover, that kind of stuff, right?
Yes,
All right. None of the LDPs had specific references to developing short-term vacation rentals.
that's correct.
Do you have a copy of It's basically the first timeline that we had as exhibit 9 last time. If you don't, I've got. You have to live with it.
No, I did not bring one with me.
Exhibit 9. The question I've got is on the second page of that, where the block is 11/13/2019. And it talks about the P and Z meeting early on with the short-term vacation rental ordinance. And there's a number of folks listed in that line that says, that those folks did not object to short-term vacation rentals. So is it that they didn't object to short-term vacation rentals as a concept? Or is it that they didn't object to short-term vacation rentals in the R1 residential district?
It was discussed that they were not opposed to short-term vacation rentals in general.
But that wasn't related to any specific project, just the overall concept.
Well, there were several different discussions going on. Some were okay with short-term vacation rentals being done up on the mountain. Others were okay with short-term vacation rentals being done on the lake.
And is that from the 4 folks that are listed there in that block, or are those other folks who were making the comments?
That would be the folks listed here, as well as some others.
But in general, that was in the context of a discussion to get to draft ordinance at the planning and zoning commission stage, right?
Well, that I did not know.
But I mean, this was during a public meeting where they were discussing it.
Yes,
And the subject matter being discussed was potential adoption of some ordinance, recommendation of some ordinance to council, planning and zoning.
possibly.
And if you'll flip over to the next, it's the next block, it's on page 3. So that block talks about motion. So it's there. I have questions on that. All right, if you could flip over to page 5. It has an entry on 7/22, about 7/22/2020, about a letter sent by Mary Beth to Johnny Irvin. So the letter is Exhibit U. And I guess I'm a little bit confused about how that is applicable to short-term vacation rentals.
That was included because we felt like that the whole situation was relevant as far as the reaction.
Well, I don't know, right? Because I don't live in Tallulah Falls, my office is in McDonough, but the way I read the letter is it looks like, and it doesn't have the correspondence that went below it, so find the letter, which is Exhibit U, that this is the letter, but and it's page 61. All right, so it looks like to me, this letter is responding to either verbal conversation or a written communication from Johnny to Mary Beth.
Well, I would agree with that.
Okay. And it looks like in this context, the response at least gives the indication that Mary Beth is talking about moving out of Tallulah Point, which I don't understand the relevancy of that to short-term vacation rentals. Especially because I think at that point, Mary Beth wasn't on council, correct?
Not at that point. She had been in the past.
Okay. So sort of come back to that about how the letter applies in this context.
Well, Mary Beth Hughes has been one of the main opposers of our project on the lake. And we included that because we felt like that was relevant.
I guess it looks like to me from the letter, and the letter before it, but it looks like to me the letter was more of a finalizing her moving out of Tallulah Point.
Well, I didn't write the letter. Mary Beth did, so
Okay.
she would have to speak to that.
Have you seen the letter that preceded that?
Which letter are you talking about? The opposition letter?
No, there may not be a letter, and you may not know. You have to ask John. He's not here, so was there a letter that preceded this one, or is phone call or what?
I do not know.
Sorry to interject, but we are a team effort, so she might not have knowledge of that.
I understand completely, and the only reason I asked her is really because it's a team effort. She may say, well, I can speak to that because of whatever, but if you can't, then yeah, that's perfect. All right.
I can, if you want me to jump in, I could
Yeah,
broaden it out.
that'd
I
be
think I
fine.
can get, all right. In the course of Miss Hughes moving out of the property on the loop, what did she do to Johnny Irvin's truck?
She slapped it.
Okay. Was this a letter that followed that? And
Yes.
so it was an incident rather than correspondence. She was following up after having an altercation where she slapped his truck and kind of lost her cool.
Okay, all right.
And then, after that, she showed up at every hearing that Irvins were involved in and took a pound of flesh. So that's why we included that.
Because, like I said, she's been one of the main opposers from the beginning of our rezoning request. It started back in 2019.
So was she asked to leave Tallulah Point?
That I do not know.
Okay. I think the lease expired.
Okay. All right, I just, point being is I didn't understand how that was relevant to the STVOs.
It was the altercation and then her subsequent hostile treatment of the Urbans that we were pointing out. And the fact she wasn't saying she was opposed to short-term vacation rentals in residential areas. She said that was okay up on the mountain, but she opposed everything that the Urbans had.
So was the lease not renewed because of her position on short-term vacation rentals?
We'd have to ask my father that, but to be honest, I've been pushing for a change in the lease, if not renewing, below the market rate she had been receiving since 1993.
Bottom line, she moved out and had an altercation in the course of doing that.
Okay, but all of that took place, at that point, she was no longer counsel, right?
Correct.
Okay, fair. And let me just ask, are these your notes or are those David's?
Those are David's notes.
Okay. I don't have any further questions. Anybody else has anything?
I think everybody knows, but Miss Hughes was on the council until 2019. Right,
Correct.
so that altercation happened within 6 months of when she served on the council.
Yes.
All right. Thank you. Yeah, anyone else?
No more witnesses.
All right, I believe our agreement was that you would have 10 minutes for closing statements.
Sure.
So if you're ready for that, we'll go ahead and move into that section.
Thank you, Mr. Mayor and council members. 8 witnesses is enough. Thank you so much for your attention tonight and in November and October of 2020. And Mr. Tilley, will you join in the council? Thanks for putting the reading on the October meeting from last year to catch up. We submitted some law on vested rights, and I won't recite all of that. You've got that. You can talk to your city attorney about it, but just in general, vested rights in Georgia, that occurs when a property owner has started developing property, has made investments, both in money and in time, and reliance on the legality of certain land uses. It's a substantial change in position by expenditures and reliance on legality. And that is what happened here with the Urban family on short-term vacation rentals on their 22 remaining lots that are before you. The existing landscape of zoning and city ordinances as of June 23rd or July 23rd, 2020 in Tallulah Falls is that short-term vacation rentals were not yet regulated, whether in residential areas or otherwise. And we have shown that through documents, through and what was before this proceeding, internal emails, which were public records, where various city officials mentioned that. But the enactment of the ordinance and the discussion of the enactment of a moratorium and the discussion of a short-term vacation rental ordinance for quite some time, the discussion about that has proven that. So, vested rights are like grandfather rights, where basically the rules get changed after money is spent and time and effort occurs in furtherance of use of land and private property rights. That's what the Urbans did relating to short-term vacation rentals. You heard that Brian Urban moved here from Charleston after spending years in the hospitality industry there. live the dream and do short-term vacation rentals here where his family's been for generations. Vested rights and grandfathering, that implicates retroactive laws and the Constitution. It's something that rises to the highest level of private property rights. And so it's an important legal matter. And we've brought literally a car full of evidence to you. The back seat and trunk of my car were full in November, and it's now in your hands in terms of witnesses and documents and evidence and emails and citations of minutes and things like that. So we've cited some Georgia cases. There was one in Morgan County that was very similar to this, where if you have an ordinance that was either vague or that explicitly just didn't weigh in on the issue of short-term vacation rentals, the Georgia courts have held that it's a constitutional issue if the government comes in and interrupts short-term vacation rentals midstream, which is what happened here on these 22 lots. The Urbans started work on it. They employed numerous professionals, whether it's James Urban, the engineer, Ronnie Davidson, the builder who built this building, City Hall, years ago. These are local professionals, and they designed, they've spent time and money lawfully exercising short-term vacation rental rights on these 22 lots, 9 of which are on the lake or near the lake, and the rest of which are up on Hickory Nut Mountain. So that's an overview of the law. We don't have lot number 4 included anymore. And I want to focus you on what's at stake in this hearing. You have things like that variance earlier where you've got to look at the whole project and you've got to worry about everything. On this vested rights proceeding, it is something that your town has never done, and I don't know of any other town or county in Georgia that have done it. Normally it's judges who do this, but the limited scope of what you're deciding is, did the Urbans have vested rights on short-term vacation rentals? That's it. You don't have to decide density. You don't have to decide townhomes. You don't have to decide access or right-of-way or railroad or Georgia Power property. You don't have to decide what the scope of the moratorium was. You don't have to decide many things. You get to take time to focus on the specific narrow issue of, did the Urbans spend time and money and reliance on the legality of short-term vacation rentals on these 22 lots before July 23rd, 2020? And the answer clearly is yes, with an abundance of evidence. So we would ask you to recognize their private property rights. David Urban sat in this chair and was asked questions about his interpretation and his beliefs. But as you see, you've got Brian Urban, you've got Clint Urban, you've got Marcia Brock, you've got Johnny Urban, you've got 2 corporate entities. And I'm here representing those 2 corporate entities that own the land. And as their attorney, I'm stating to you that all this proceeding decides is short-term vacation rental rights, vested rights on the 22 lots. Issues about townhomes, density, access, everything else that could be handled over time and deliberation on a different date. And you can see Clint Urban nodding. You can see Brian Urban nodding. We're here telling you that on the record. That's what our application requests. We've limited the issues that will keep the town out of court to honor the vested rights, make that decision on this issue, and then we can approach issues that are in addition to that in the future as under the city's ordinances and different proceedings. So the only issue in this proceeding is vested rights on short-term vacation rentals on raw land lots. Also, the operative date is July 23rd, 2020. There was some questioning and discussion at the second or the third meetings about the moratorium. And the moratorium had certain language in it, which it is what it is, but it talked about regulation, revenue, things like that. Mr. Tillery's letter, which is now before you in the supplement, March 30th, 2020, talked about the orderly proliferation of short-term vacation rentals in Tallulah Falls at that late date in March 30th of 2020. And so all the discussion about short-term vacation rental ordinance changes up until the very end was about orderly regulation and taxation, revenue, things like that, which the Urbans fully support. You heard David Urban, he used to work as an auditor in state government, and the Urban family is comfortable with regulation and revenue going to the government and having standards on short-term vacation rentals. The issue here is on these 22 residential lots. You have all the other residential lots, they're gone, they're off the books. But these 22, the Urbans raised their hands prior to when the ordinance was enacted and said, we have spent time and money, please honor our vested rights. And in the supplement, we gave you the red line from before the ordinance was enacted. My colleague at my law firm, Sean Adams, who appeared before you, he spent time and resources redlining that ordinance to protect the Urban's vested rights. And the city did not adopt those changes, but the city adopted the vested rights paragraph. And that is what has led us here to review the evidence. And you can see that both on Hickory Nut Mountain and down by the lake, the Urban spent time and money on short-term vacation rentals in reliance on the current state of the law before July 20th, 2020. And that's why we're asking you to say, yes, they have vested rights. The issue is not what the town knew about the Urbans. The issue is what the Urbans did and what money they spent and actions they took in reliance on what the town's ordinances were. What the town did, what the town said, what the town's emails said, which have been placed before you. And so the flipping it around and saying, well, we didn't know what the Urbans were doing. Number one, we'll show you that was presented to the town, but the legally significant issue is, what did the Urbans do and what money did they spend in reliance on the legality of short-term vacation rentals before July 23rd, 2020. And as you can see before you, there's overwhelming evidence that they had exercised their rights and that they had articulated what they were doing in the city before the ordinance was enacted. And that's why we're asking you to honor those rights by granting this application. And look, you're now a year and a half after the ordinance has been done. You don't have others of these pending. So this is a very narrow proceeding on 22 lots out of all the residential lots in the town. Honoring the Urban's rights on these 22 lots will not alter the big picture in the town. The town's actions, comments, and emails are relevant in this proceeding, though, to show evidence of the legality of short-term vacation rentals in Tallulah Falls before the ordinance was enacted in July of 2020. And what we've seen, number one, you've got the timeline there, but we've seen in the discussion of the McDaniel property on Hickory Nut Mountain Road, they were doing short-term vacation rentals and advertising on the web. There were comments by city officials that there were residential landowners doing short-term vacation rentals under the radar, but out on the internet. So maybe it wasn't, officially with the city, but it definitely was publicized. They were doing short-term vacation rentals. Additionally, Raven County, other towns in the area, and Raven and Habersham County, people were doing short-term vacation rentals in residential areas more and more every month that went by without an ordinance in place or even with ordinances that allowed it in residential areas. So the landscape of the ordinance in July of 2020 was short-term vacation rentals being legal and going on all over the place in the area.
Okay, Matt, you hit your 10 minutes.
10 minutes.
So go ahead.
All right, I will wrap up. You've heard 8 witnesses. You've heard a lot of evidence. You've heard various current or former city officials saying they're okay with it up the mountain. We've got lots both on the lake and up on the mountain. You have alternatives. You heard it from Johnny Irvin last time. Mediation, settlement. You have reasonable property owners who will work with the town. You can file a declaratory judgment action in Raven County Court. If you're uncomfortable making this legal determination on your own, you can talk to the city attorney about putting this in a court's hands. You have a property owner who's willing to discuss settlement with you. You have 30 days to make a good decision, and you have a property owner who you heard last time and you've seen over the years cares deeply about the community. They're looking you in the eyes tonight, can confirm that. They want a win-win in Tallulah Falls on these lots. So we would ask you to be fair and reasonable honor constitutional rights and private property rights, and protect the private property rights, just like that March 30th letter in the supplement says, protect those private property rights and grant the vested rights application. And we are on call anytime over the next 30 days to discuss it with you. Thank you for your time and attention in this unique and unusual proceeding. And we ask you to honor the Urban's vested rights, grandfather rights, and grant the application.
All right. That is all. Warren, you have, I don't think there's any,
I don't think our procedures really provide for any of that. I think we just move to.
all right, we'll move on to the deliberation. So we'll close out the vested rights hearing and move to the deliberation on the determination of vested rights from the council.
I'll lead with this, the ordinance dealing with this proceeding specifies that town council shall render a final written decision on the application within 30 days of the hearing. So that means we'd have to write it, whatever the decision is, and prove it. So while I think it's fair for y'all to deliberate on that tonight, that's something basically makes it where the decision may not be made tonight. And the other guiding principle on that, and I'll tell you, is that with vested rights, at least in my mind, I think it has to be on almost a lot by lot basis here. Meaning that it's not necessarily an all or nothing situation. You've got the deeds in the application. You can see when those properties purchased, in those timelines. You can see when they did certain actions related to certain tracks. They're kind of divided up into different units. So I'm not, all I'm trying to drive home for you all is that in this decision, it does not have to be an all or nothing situation.
So do you guys discuss among yourselves or how y'all want to proceed? Y'all make a decision, make a determination and direct Warren how to write a letter. If y'all want a little more time to consider the new evidence or any new evidence. Got any questions?
The only question I have is these discussions that if we decide to go, they have to be done. I mean, how's that done? We can't go out.
Would these discuss, would our part of this discussion not be done in executive session?
I mean, where would we discuss this? Is what I'm trying to get at.
And on behalf of the applicant, I would say we're fine with recessing the executive session or doing whatever you need to do with council to, with your council to be able to deliberate on this important legal matter. I don't want to stand in the way of that. I want to facilitate that as the applicant's attorney.
We appreciate that. I'm just concerned about the states, what the state would say with us going into executive session. But, you know, we want to keep within those rules as tight as we can.
And look, I'll if we didn't, despite my giving the closing statement or whatever, if there's a need to adjourn and reconvene with notice for executive session, we're glad to cooperate with council on that and, you know, take the order differently.
That may be a way to do it. In general, your executive sessions under the Open Meetings Act or potential litigation, real estate, personnel. As a sit here, it seems like with the number of anti-litem notices, this may be something that could be qualified for that. On the flip side of it, I mean, we're in this posture also, the adjudicating body on that question of STVR vested rights. So, that's something that we know at a minimum, we're gonna have to issue a written decision on this. So if this is something that you all would like to recess for tonight, or pin in, we can have a, different day. I know it's tight with the holidays, but perhaps the better discussion is, when do you all want to get back together to do that?
Have these discussions, we've got to have another meeting during the executive session.
Well, we've got space for executive session tonight, or we can do it another night.
Yeah. because,
We will have to, regardless, there will be a meeting need to be scheduled once the letter is drafted for you guys to approve my signature. So if you have another deliberation meeting, and you make a determination, Warren has to write a letter, and we still have to get back together that last time. Now, that can potentially be done in January, but that would, without our fourth council member involved, the one that be coming in, Larry's going out. So that's the only reason we're trying to keep them in a certain time frame if we can. But I know, I realize it's tight. And since we only need three council members for 4, we still have that flexibility. Even in January, we have to.
And also during and after the decision, again, Johnny Irvin had me say it last time, and I've tried to say it tonight, we're willing to do settlement, mediate, whatever. Whether that's with full board, a public meeting, or a designee and legal counsel. We're glad to talk to the town or whatever you and your attorney are comfortable with in terms of the setting on that. But the Irvins will do their part on trying to find a common ground.
What does that mean? Specifically,
In terms of
common ground.
in terms of last month, I know there were a lot of questions about townhomes and what's going to happen if the vested rights get approved. And the Irvins have, wide spectrum A to Z of what they, are willing to do, plan A, B, C, D, E, F, G on these 22 lots. So if you approve vested rights, number one, they're not going to come in tomorrow and try to do something, but they're also glad to have some give and take on something. They welcome feedback and ideas on how to do short-term vacation rentals on these 22 lots in a way that would be acceptable to the town.
I know now, I've heard David say it, that if he gets a variance, that he feels that the proposed way, you want to call it, the 18 unit is a guarantee because of the variance. He stated that. I've heard that in my head.
He is, well,
Does that
let
make
me answer,
I know, I just-
Clint could follow up. Well, and if we go to court, definitely, that's what they've spent all that money doing it. If we go to court, they reserve the right to do it. If we have approval of the 22 lots, we start from scratch with you all and determining what to do with short-term vacation rentals on those 22 lots. So it depends on at what point the decision's made. If 22 lots are approved for short-term vacation rentals, we come in and sit down and ask, what's next? If it goes to court, definitely you've seen the plans on that. And he reserves the right to do that. But we're asking for short-term vacation rental approval on the 22 lots, and I'll turn it over to Clint.
I'll say this, we are a small local family company, and what David said is how he feels, but he's not the law. If you approve vested rights application, you approve our vested rights, we still have to fall within R1 density requirements, because those have been the way they've always been, as far as I know, for the past, 20, 30 years. So when it comes to this big old 18-unit project, that's not the decision. So if we get our vested rights, then we have for the 22 lots, that's what we have. Now, if David and everyone comes in here and says, hey, we'd like to raise the density requirements on these R1s to 45, the town goes, no, it's R1. We still have our vested rights for those 22 lots. I hope that provides a little bit of clarity.
And also they're separate. You've got the 9 lots on the lake, you've got the other lots up on the mountain. So the order of development, there are all sorts of varieties of ways to make this an orderly proliferation of short-term vacation rental rights. They've never said they want to build all 22 lots at one time. So spacing it out and having some sort of give and take on how to approach this, they're open to doing that. In terms of how to talk settlement, you can have an open meeting where it's done. You can have a lawyer and one designee, and then come back to open meetings. There are a variety of ways the settlement can occur. You can have a mediation schedule where you bring in a former judge or senior lawyer and have, designees of the city to come report back on what is generated from mediation. There are just a lot of alternatives to a yay or nay decision that could, put us into court. The Irvins are glad to explore whatever options there are out there to see what common ground looks like.
All right, so I guess the question is, do you guys want to meet with our legal counsel? Get any information from him? If there's any further discussion, do you want to go ahead and discuss y'all's thoughts?
I would feel more comfortable discussing this in executive session with council. If we can do that within the confines of the law, and I think we can because it's a real estate issue. It's always been my understanding that you can discuss real estate in executive session.
No, think it'd be fall under potential litigation.
So I'll let you start potential litigation, either one litigation, real estate. But I'll let you guys be the lawyer part of it.
Just let him be the lawyer.
Yeah,
Okay.
so it is definitely seemingly straightforward question. There have been circumstances where I've served as the advisor to boards, like boards of zoning appeals and stuff in the past, where it has gotten more gray than just that. So I guess what I'm saying is, my recommendation would be, give me a day or two to make sure of that. And go ahead and talk about the date, I know it's the holidays are coming up, but I'm certainly open later part of next week, if that works. If you want to do it some other time, I'll make myself available. But I'd like to nail that part of it down before we just go and do it, because coming back to Mike's point, I know they don't have a problem with it. I don't know that I'm gonna have a problem with it either, but I'd prefer not to have, the AG's office come knocking on our door about going into executive session over stuff.
That's why I say if we can do it under the confines of the law. And I understand we have, our response needs to be done in the form of a letter, a written letter.
Well, it's gotta be written,
Yeah, and we have 30 days to do that, so I think now in our final response in the form of a letter through the attorney, that if we can work it out schedule wise, need an executive session, talk it over, detail, so that would be my recommendation or suggestion.
Okay, so my schedule is good for next week. It's pretty open. In fact, looks like I'm open right up until we leave for Christmas. and the following week. So are you guys,
It's not Monday or Tuesday.
okay, Monday and Tuesday are out?
Yeah, I'm staying Monday and Tuesday, but not Wednesday, Thursday.
Wednesday or Thursday.
Okay, so
Wednesday or Thursday.
Wednesday, Thursday, I have a preference. Wednesday, that's one day closer.
Wednesday was fine.
Okay, I'm just scheduled for Wednesday.
What time?
I'm available anytime after lunch.
I just don't want to be here all night, so we need to go early or
Right.
whatever.
Larry, your schedule's still pretty open.
Time
Filled it yet?
and place.
All right, I've got a meeting at 10. So,
Thursday, we're going.
I can be back fairly early. Oh, so a different time frame next sheet, it's 11. No, it's 9 here.
39 in there. No, it's 10, it'd be 10,
Yeah.
it'd be 11 here. We have family.
Oh, wait a
so
minute. It says 10 here, it's 9 AM. Have a
9 AM there, okay.
Yeah, I can get that.
Back by 3, so if you're scheduled for 4, would you be able to do that?
4?
4 or 5 be better? I know you got school,
better.
at school,
I'm out 4.
you're out at 4.
Well, what day,
Wednesday at 4?
Sounds like 5. would be
5 would
better
be
than
better.
Okay.
Wednesday at
5. Check here, well, so that means Warren will have to leave at 3 in the morning.
We're doing it at 5 AM, you said?
Or 5 PM, you have to leave the night before if we get better.
Yeah. What, so Wednesday.
5 o'clock Wednesday. For an executive session. And then
If my,
based on,
if my opinion changes on that, then we'll, I'll let you know, but otherwise.
then we'll turn it into an open meeting. We'll set the meeting date and
We're
determine. based
gonna
on-
we're gonna plan to meet here at 5 PM on Wednesday,
There you go.
December 15th. And
That's it.
How and where we conduct that, or, parameters of that, I'll have you.
We will have to have that. Wait a minute, can we get that in the paper? So we have to have special meetings in the paper. Okay, that's right. Just notice 24 hours or whatever. Okay, so we get, yeah, we do. Okay. All right, so there is no old business, so the new business will be to set our January organizational regular meeting date.
Is that the 15th?
Yeah.
Right. Oh, is it the 15th?
I'm sorry.
January?
Of January.
No, he's still-
I'm
Sorry,
December.
he's on the
Oh,
executive
oh, oh.
session.
he's still
The
taking
executive
his-
session would be next Wednesday,
The 15th.
15th, December 15th, correct.
Yeah, sorry.
January is the
13th.
if we go with the date, and I won't be.
That'll be,
Do y'all want to take a moment? We can maybe let her go, because we got a lot of dates flying around now.
Yeah.
okay, yeah, I mean, that's really the last thing we're gonna be discussing
all right,
anyway,
all right.
so yes, you can. Yeah, we can.
Will you need me for your next?
No, we are done.
Okay, if you change your mind, you can go ahead and know that you vote to make a vote.
Oh, I see what you mean.
Yeah.
For that one.
Yeah.
Okay, Ellen.
Yeah.
Okay.
Okay. So, yeah, we'll, the only 2 dates we're looking at, or the only 2 dates right now is December 15th for our next executive session. Then, right now tentatively, we've got January 13th at 6 for our regular council meeting, which will be to swear in our new council member and then take care of we've got a business organizational part of that meeting, some structural things we have to take care of. You won't be here, so you get nominated for all the positions.
The best I can do is.
And we have a public hearing, so is the. The Thursday before would have
Would be
been
the
our, would have been our normal regular council meeting, had we not made those changes. But getting the reports together, we need to have New Year's. Really tight. But can you do the 6th?
Right now, the way I'm looking at it, I could do it 6.
Would the 6th work better? Okay. Let's push it to the 6th because we need to have a quorum, and if something comes up, it'd be better to know most everybody can be here. So,
I would my player.
So our next regular council meeting will be January 6th. We will have a special meeting on December 15th, next Wednesday, for executive, to go into executive session. All right, I had some mayor comments, but the trees, I don't know if you noticed, we took the trees down, finally got those taken care of. And the Christmas party was fun with the students. We enjoyed it. We'll go ahead and move into public comments. David's bouncing out of his chair.
Yes, I have a public comment.
All right.
Where the River Street divides around the Big Rock,
Yes, sir.
coming up the mountain, I have seen people go to the left. I don't know why they go to the left. There is a sign that has a little, thing with an arrow that goes around it. You would think that that would be sufficient to have people go to the right.
Right.
Now, if you're coming down the mountain, there's a sign that says, keep right with an arrow. There's like no interpretation. So I was just maybe suggesting that maybe, on coming up the mountain, we'd say keep right, idiot. You could use that, you could use that word, but, keep right with an arrow, maybe, maybe that is, would not be subject to interpretation.
I know we've talked about possibly putting a guardrail up there. That may be part of the reason. Is people, don't want to veer that close to the cliff or lake. So, but yeah, I don't think that'd be a bad idea. Put a keep right
I
sign.
don't know if the DOT, has regulations.
Would be,
Kind of thing.
I think that falls under us. So I think we can.
Okay.
We can look
Just
into
a
that.
suggestion.
All right.
Sorry.
The other,
Yes, hey, Doug, just a question with the vested right. What is the process from this point? So December 15th will be possibly the executive session. And the reason I'm pointing that out for all parties, for both sides involved, we have a new council member coming in, so we start getting them up to speed. So what's the process from December the 15th? What are the options?
the options are to
Many? I guess?
Yeah. See what our legal counsel comes to us with and how the council decides to move forward. I mean, we would like to try to get it taken care of before the new council member comes on. We have given him information, but even at that late stage of the game, we've got some other things we're talking about. If it gets to that point, we're just hoping it does. I think we'll make a determination based on that meeting and set the final meeting date where the council will announce their decision, and then Warren will should have something for us, I hope.
Yeah, it's. We gotta have time to write it, so.
Understood.
But.
Any public comment?
Yeah, I would like to take an opportunity to thank Larry Hamilton for the years he's been on the council and contributed to the community.
Thank y'all. I appreciate your support. It's been fun. It's only been 24 years. I can't have all the fun and I have to share.
Yeah, we're gonna have him meet with our new council member so he can tell him where all the dead bodies are. No, so we're actually gonna get him together with our new water commissioner at some point. whoever that is, so get some more information from that. So, That's fine. No, that's fine. Any other public comment, anyone on Zoom? So that's a no, so I'll ask for a motion to adjourn. Joey makes that motion on second. Tom seconds, all in favor? Yeah, all right. Congratulations.
Oops.